and it will be uploaded, within the week, and you'll get a notice about it. I'm going to really open it up to Angela to do her thing. I will moderate as far as if there are any questions, but I encourage you to write your questions in the chat box just to remind you so we can go back and make sure that they're all answered. And I did also give her 2 questions that came in from 2 registrations earlier this week. Angela?
Okay. Hi. So I am an attorney that's been doing probate work for 31 years, and I'm also the probate judge now in Orleans County. The biggest question I get is, does a will make it so you don't have to go through probate? And the answer to that is no. So having a will does not save you from probate court. A will would still go through probate. It just tells the judge what to do. If you don't have a will, what happens is your estate goes through what they call intestacy. So intestacy law is the law the state says, hey, if you don't have a will, this is who we give your stuff to. The stuff people think goes to the state or to the court, and it doesn't. In 31 years, I've never seen an estate go to the state. But if you have not done a will and you have no relatives to the 5th degree, then I believe the Department of Education gets it. Haven't seen that happen, but it can, in theory. So how does intestacy work? Intestacy says it gives the lineup of who gets what. So it really depends on what your family consists of. Most people agree with what intestacy law is unless they have a blended family. So a blended family can complicate probate quite a bit. One of the things, I'll go back to wills for a second because I remember one of the questions. So one of the questions was, hey, if I have a will and I want to make a change, do I have to do a whole new will? You don't have to do a whole new will, but you do have to do what they call a codicil. So let's say you have you have listed a bunch of things you want to go places, but now you decided you want the antique, spoons to go to somebody else. You can do a codicil saying, I delete the antique spoon clause, and now I want those to go to so-and-so. And then you still have to sign the codicil the same way you would sign a will, which in Vermont is 2 witnesses. So, and those witnesses have to see you sign, and they have to see the other witnesses sign, and they cannot be anybody mentioned in the will. Common mistake. People will come in with a homegrown will, and I've seen a few of them done right, and they're wonderful. But one of the biggest problems have the right witnesses. So you can't have anybody mentioned in the will or anybody married to somebody mentioned in the will. So if you're leaving me something, you can't have my husband or my child witness the document. Okay. It won't void the will. It will void whatever's going to me. Okay. So, which kind of defeats your purpose. So the other thing about a will is it is public information once it's put into probate court. Now, it's not public until you die. So a lot of people store their will in probate court, and even the court doesn't read it until you've passed away. But once you've passed away and somebody starts an estate and the will is opened, that is public record and anybody has a right to look at it. Okay, there's no right to privacy there. One of the biggest complaints I get at probate court is, oh, so-and-so is not a family member and they shouldn't be in this hearing. Well, unfortunately, probate court doesn't have the ability to kick anybody out of a hearing unless they're being disruptive. Now, that's not true for like guardianships and adoptions, but for wills and estates, all public. Okay. So a will doesn't keep your stuff private, and it doesn't keep you out of probate. The other, and estate tax, the other big question I get a lot, and it wasn't in the list here, but is you don't want to pay estate taxes. In the US, you don't pay estate taxes until you have at least $12 million. So if you have at least $12 million, I would send you to a very big firm in Burlington. I wouldn't even try to do your will. So unless you have more than $12 million, you're pretty safe. There's no estate tax. You don't have to worry. And you can even get out of gift tax. So people will look up what's the gift tax exclusion, and that is about $18,000 a year right now. However, let's say you want to give your kid $100,000 and you don't want to pay gift tax, or you don't want them to pay gift tax on the other $82,000. You can use up some of your $12 million death credit. So you can use that during your life. Okay, so if you use up $82,000 of your death credit, when you die, you now have 12 million minus 82,000 in death credit. Okay, so you have a 12 million lifetime exclusion for each of you. So if you're married, each of you has a $12 million exclusion. Okay. So one of the, well, I won't get to POAs quite yet. So so what happens if you don't have a will? Well, that's called intestacy. The common intestate laws are everything goes to, if you're married, it'll go to your spouse if it's your first marriage. If this is not your first marriage, then it gets complicated, because then you have to, if there's children of a first relationship, I shouldn't even say first marriage. If you have children from somebody other than your spouse, whether they're the first spouse or not, if you have children with someone other than your spouse, then it doesn't all go to spouse. What will happen is 50% goes to spouse, 50% to child. Okay, so that's why blended families are harder. And it's because people often come in with children on both sides. And so now, if you've got a couple that has children that are not children of the marriage, then the spouse gets 50% and the children divide the remaining 50%. Okay, but the normal court, you know, the old traditional course of things is how intestacy is set up. So first marriage or first relationship, spouse gets 100%. If both of you are gone, then kids get 100% and they divide it equally. If, God forbid, one of the children has passed, their children will get their share. Okay, and it keeps going down. So so if you have 3 children and one of them has passed, and that one that has passed has 2 kids, the 2 kids split the deceased child's 1/3. Okay, they don't come up and now change your other children's share into force. They split the 1/3. If you have no children, it goes up to your parents, if your parents are alive. If your parents are not alive, it'll go out to your siblings. If your siblings are not alive, it'll go to your nieces and nephews. If your nieces and nephews are not alive, it'll go to your great nieces and nephews. So basically, if you think of a family tree, intestacy tries to stay in a straight line, but if it can't, it'll go out into the branches and down, just like if you're drawing a family tree. Okay. The biggest issue we have as far as people fighting in probate court is generally the blended family issue, where a spouse takes against the estate. So the only person you cannot leave out of your will is your spouse. And I lie a little bit, because if you have a prenuptial agreement that says, I can leave my spouse out of my will. Then you can leave your spouse out of your will. But other than that, and most people don't have that, then you cannot leave your spouse out. So let's say you do. Let's say you agreed to, both of you agreed and said, hey, we're going to leave each other out, and my stuff's going to go to my kids and your stuff's going to go to your kids, and we're all great. And then the first spouse dies. Extremely common that the spouse takes against the estate. Now that means they are claiming their spousal share against the estate. And people will argue about, oh, they didn't get along, or that wasn't the agreement, or whatever. But the reality is, if they can produce a marriage certificate and nobody can produce a divorce certificate, they win. It doesn't matter how well they get along. Doesn't matter if they were in the middle of getting divorced or if they were squabbling, or none of that matters. Doesn't matter if one was abusive, none of it matters. If they can prove they were married, still married, they get spousal share. And spousal share is $125,000 in the homestead and half the remainder. They can also ask for some things like personal furnishings and spousal support. And if there's minor children, they can ask for child support. So you can't leave your spouse out. People try to all the time. They think they've agreed. Not all the time, but many times the spouse, once one passes, the remaining spouse does claim against the estate, even though the estate plan they drew up together leaves one spouse out. So what's the advantage to having a will? A will is a big deal if, well, let me back up. I tell people, you don't need a will if you want things to go the way intestacy goes. So if you want everything to go to your spouse and everything to go to your children, and you don't have a blended family, then you don't really need a will. The only thing the will is going to do for you is say who you want to be executor. So why go through the expense of doing a will? There's not really a big reason to. What I tell people to do instead is skip probate. Just don't do a will and don't go to probate court. If your assets and your family situation is set up such that you can avoid probate, you should do that. And I don't say that just because I don't want the work. I say it because I don't want people to have to spend all that time in probate court. Court is slow. Doesn't matter how efficient people are, court is slow. It's not that expensive in Vermont. People worry about the expense of it. Not a huge expense in Vermont. The court fees are minimal. I think it's, there's a couple things you have to pay $100 for. The admittance fee in court depends on how big your estate is. So if your estate is, 50,000 or under, there's, I don't know, I don't remember the fees, but they're like 50, it's like 50 or $60 or something. And then it graduates up. And I've seen fees for like $2,000 if it's, a several $1,000,000 estate. But basically the court fees aren't very much, in comparison to your estate. Some people hire an attorney. That might be a lot of money. There is no requirement in Vermont, and I would say probably 80% of the cases in Orleans County, there's no attorney involved. But some people hire an attorney, and some attorneys are very expensive. I guess no one would ever say that there's an inexpensive attorney, but some attorneys charge a lot more than others, let's say. So you should check with the attorney on that. Basically, the ones in Orleans County, Caledonia County are fairly inexpensive. Once you get to Lamoille and Chittenden, you can start racking up some pretty high attorney bills. So that can be an expensive part of probate. But the bigger reason to avoid probate is just ease of your family. So I tell people to avoid it. Most people's biggest asset is their home. For your home, there's something called an enhanced life estate deed. Okay, an enhanced life estate deed. You've also heard it called a ladybird deed. You've heard it called maybe a contingent remainder deed. They're all the same thing. It says, here, usually children, here children, here's the house and the land. We're going to keep the right to live here for the rest of our life. We're going to keep the right to sell, mortgage, or lease the property for the rest of our life. If we happen to own this house when we die, it's yours. All the kids do when you pass, or whoever you deeded it to when you pass, is record your death certificates, and they're done. They own the house. They don't have to go to probate. They don't have to do anything fancy. They just record your death certificate. And sometimes they don't even have to do that. If you die in the town you live in, they don't even have to do that because it'll automatically be recorded there anyway. Sometimes that's actually too easy for the kids. They just don't even believe you. Okay. When you refer to a estate, does that mean everything that is left over? We'll talk about that. Good question. So life estate deed, in my life estate deeds, I also put the personal property in there. So I will say, hey, this is my home and all the land attached to it and all my stuff. So your couch, your chairs, your forks, your lawnmower, all that stuff. You can also do a very similar document for your vehicles now. Vermont didn't have this until about a year ago, but now you can do a transfer on death form for your vehicle if you own it. If you don't own it, that's a problem. But if you
And
own
so
it,
that would, when you say if you don't own it, I mean, it was an aha for us, or for me. But a reminder that we are leasing our vehicles, so therefore it doesn't qualify. So
right.
something to remember is, oh, right, I'm leasing it instead of I own it.
Yes, very good point. So if you're leasing it, the lease company is going to come back and get the car.
Mhm.
Unless, your heirs pay it off and go through an estate and that kind of thing. But if you own your car, or actually I shouldn't say car, any vehicle, anything with a vehicle title, could be your boat, your trailer, your truck, anything that you would normally register with DMV. There is now a form on the DMV website that is called a transfer on death form. You can use that form to transfer your vehicles on death to your heirs or whoever you want it to go to. It can go to your grandkids, whoever. And they can't stop you from selling it. They can't stop you from giving it to somebody else even. It's the same type of document. Basically, if you own that vehicle when you die, it's the person you listed. Until then, they have no say, no liability, no anything to do with the vehicle. Those are called future gifts. So they're not gifts right now. And the reason I say that is if you have to apply for Medicaid, one of the things they ask you is, have you given anything away in the last 5 years? For either one of those documents, you can say no. So you can sign an enhanced life estate deed and a transfer on death form for your vehicle today. Apply for Medicaid tomorrow, and in the question where it says, have you given anything away in the last 5 years? The answer is no. Now, some people write yes and just provide a copy of the documents they just signed. And that clears up any confusion that Medicaid might have. But those documents are exempt. Okay, you can use those documents. The beauty of them is you don't go through probate court, and Medicaid won't take those things away from you or away from your heirs. Okay, so Medicaid planning in this area is probably 75% of the people I see, because Medicaid planning is especially important if you don't have $750,000 in the bank, and most of us don't. So the reason I use that number is that's what it costs to pay for 5 years of care in a nursing home. So if you can't pay for 5 years of care in a nursing home, then you need to do Medicaid planning, which is probably more important than probate planning. those documents take care of a majority of what most people come in with. Now, there's a couple other things. There's something called in trust for or pay on death account. And that's for your bank accounts. Basically, you are listing a beneficiary. So you know how like your retirement accounts, you've listed beneficiaries. These accounts aren't retirement accounts. They are just your regular savings account or your Christmas club or your, whatever funds you have sitting in a bank somewhere. You can set them up with the bank as in trust for or pay on death accounts. The reason I use two different names is the banks call them different things. So some banks say in trust for and some banks say pay on death. Basically, you're not adding your kids or your loved ones to your account, but you are saying, hey, if I'm gone and they come in with a death certificate, they get the account. It does not give them access to those accounts right now. They can't boss you around on those accounts. They can't take anything from those accounts. They have no say until they have your death certificate in hand. Okay. Though, and again, what that does, that doesn't save those accounts from Medicaid. What it does is it saves it from probate. So if you need Medicaid, chances are you're going to spend the money in those accounts. And you can. Just because you listed somebody to get them only means they get them if you die. If you use them during life, that's fine. And Medicaid will usually make you use those accounts. But at least hey, if I don't need Medicaid planning and I don't need to use this money, when I die, this person gets it, again, without going through probate court. Some banks take 30 days for those. They won't just hand them over. I don't know what their 30-day thing is, but they have a 30-day thing. So they hand the death certificate over and they wait 30 days and then they get the money. Checking accounts are the hardest. So checking accounts to stay out of probate, you have to add somebody as an owner on the account. That owner can go into your account and clean it out. You have to be careful of that. Sometimes it's not even the kid. I always say kid because usually people put kids on. But so let's say you put your kid on and your kid is the most trustworthy kid in the world and they never would take your money. However, they get into a car accident or they owe child support or they owe the IRS or the state government. Those folks can go in and take the money out. Okay. Or they file bankruptcy, something like that. That can create a problem where your kid didn't take the money.
So
go ahead.
I was buying a car, being a, what do you call it? What is it called?
Cosigner?
Yes, a cosigner. Thank you very much. Is that a similar equivalent?
Yes. So if you
Okay.
co-sign a loan and they don't pay it,
Right.
yes, then your account would be up for grabs. Yeah.
Okay. And I have two quick questions, only because I'm me. So you mentioned Medicaid planning. Can you give me tell us more about what that is and maybe some, what the impact would be and why would you do that?
Okay. So Medicaid planning is if you can't pay for a nursing home for 5 years, then you would have to apply for Medicaid to help pay for that because Medicare will not. Medicare will help pay, I think, the first 90 or 100 days. So if you break a hip and you have to go in for rehab and then you're going back home, you don't have a Medicaid worry usually. Because Medicare, that's just considered a medical expense. But once you're going to stay at a nursing home and I always kind of say nursing home, or you're going to get care in your home for more than like 20 hours a week. And that's going to be kind of a continuous or permanent situation. You have to start paying for the nursing home. And they will want you to pay all of your income towards it and some of your assets. And that can get kind of complicated. So if you have a spouse at home, you can save some assets. normally, whether you have a spouse at home or not, they're not going to come and take your house from you. However, they're also not going to leave you enough money to pay the taxes and insurance on it. So, especially if you have no spouse, your house is now empty. It can create a problem. Medicaid won't go after the house, but you could lose it at tax sale. But let's say somebody pays all that stuff. What they will do is go after it when you die. And they file a claim against the estate. And that's why if you can stay out of having an estate, they don't get to file a claim. So if you have put that house in an enhanced life estate deed, they never get the house.
And quick question on the enhanced life estate deed, it doesn't have to be family members. You
That's right.
could, have somebody else near and dear to you.
Yep. The only hang up with non-family members, or I should say non-lineal descendants. So if you give it to your folks or your kids or your grandkids, there's no transfer tax. If you give it to a strange, somebody who's not in that line, you give it to a niece or a nephew or me, they have to pay a transfer tax. Okay. So there would be a transfer tax, and that's a sales tax on property. It's not a huge amount, but it can feel big. Especially, if you got a $300,000 house, they could pay several $1,000s in sales tax.
Okay.
So Medicaid is a big deal, and very few of us end up in a nursing home, but when we do, it is a very expensive proposition. It's about $150,000 a year now to be in a nursing home. Now, some of them in Chittenden are actually a lot more than that. But the normal nursing home is about 12,000, a little over 11 a month now. So 11, 12,000. I tell people if you have assets that sometimes it's better to just pay for care in your home, because you're going to get doted on more. You're going to get better taken care of, not because the folks at nursing homes aren't trying, but they got 5 or 10 people to take care of. Whereas if you're at home, they got you, and that's cool. But anyway, so nursing, Medicaid planning is a big deal. Does that answer your question?
I think so. Does anybody else have any questions about Medicaid planning? Yeah, Beth, go ahead.
Muted.
Unmute.
Hi, thanks for taking my question. If
Sure.
you have your home in trust and if you have your home in trust, can that keep it out of Medicaid's hands?
Well, most people who have gone and gotten a trust think it does, but most trusts do not. So if your trust is revocable, which most people's are, then no, that is not a Medicaid planning tool. And I have an awful lot of very disappointed clients come in and say, oh, my house is fine, and it isn't. Okay. So revocable trusts do not provide you any Medicaid protection at all. Okay. The only trust that might provide Medicaid protection is an irrevocable trust. Okay. And
what's the difference? Can you define that?
Yep. The difference is the irrevocable trust you can't change. Once you put all your stuff in there, you can't change it.
Okay.
A revocable one you can change.
Okay.
So what an awful lot of attorneys around here have done is revocable trusts. And people come into my office all the time thinking, hey, I'm all set for Medicaid, and they are not. Now, one area attorney has started doing an enhanced life estate deed into a revocable trust. Not real sure why, but that's what they're doing. Once in a while, there's a real reason to do it, but most of the time there isn't. But whatever. Everybody's circumstance is a little bit different. But
thank you.
The revocable trust alone, deeding your house into a revocable trust without making it an enhanced life estate deed, does not save you from Medicaid. So
thank you.
You're welcome. So if you have a revocable trust, you should have your attorney look at it. Now, one of the big problems with the trusts are attorneys' moral stance on Medicaid. So and I didn't realize this was such a thing, but there are many attorneys who do not believe in making you Medicaid protected. And they don't believe in it because they think, hey, taxpayers shouldn't pay for your care, so you can give your house to your kids.
Mm.
And other attorneys are like, no, let's give your house to your kids. And you've worked hard all your life. That's I can understand why you can't give zillions of dollars to your kids, but your home, give it to your kids. So it really depends on what kind of attorney you go to, and people don't know to ask that. They don't know to ask what's your tax preferences. So I've talked to an awful lot of attorneys after the clients come in thinking they're all protected. And they've said, no, we don't believe in that type of trust. We won't do one.
Wow.
So they aren't Medicaid protected. They paid thousands of dollars for a trust, and they are not Medicaid protected. And it used to be not so much of an issue, because it used to be if you'd put it in trust 5 years ago, you were okay. But now you have to have put it in an irrevocable trust 5 years ago. If you just put your stuff in a revocable trust, you could have done it 20 years ago, and it's not protected.
Mm.
Okay. So really look at your trusts if you have one. There's an awful lot of trust attorneys who just don't believe in Medicaid planning, or most of their clients don't need Medicaid planning. Like if you went to Burlington, a lot of times they just didn't need it. Because they have a much different clientele than we might have here in Orleans County. Or at least than I have in Orleans County. You had a second question, Trish.
I don't remember it, but I have another question. Could you answer a very general question? If you could define, you were saying, you can avoid, probate, or you can trigger probate. I think you've walked us through some of that steps, but do you mind being a little bit more explicit on that?
Okay, so avoiding probate basically means making sure all of your assets are titled in a way to not become probate material. And I think this might start answering one of the questions that was asked. So what property has to go through probate? It's anything titled in your name that hasn't got a beneficiary on it. Okay, so most of the time your retirement accounts have beneficiaries. And usually they even have contingent beneficiaries. So it might say, hey, to my kid, and if that kid's gone, I want it to go to my grandkid. So as long as your retirement accounts have that, it's never coming to probate court. And I've even had people come to court and say, I want you to assert jurisdiction over that retirement account. And I can't. As probate judge, that is not a probate asset if either the contract or the beneficiaries say, hey, this is where it goes. So I've even had cases where they didn't list beneficiaries, but the contract that the employer had with the investor was, hey, if you die, it goes to this person. And if they're not alive, to this person. And if they're not alive, to this person. And so it doesn't ever come into probate jurisdiction.
Mm.
People often think I can drag assets that were given away a while ago into probate jurisdiction. So people come in and say, mom's will says we all split the house, but mom gave the house a couple years ago to just Joe in an enhanced life estate deed, and we want you to grab the house and make it split between all of us. And I can't do that. It went outside the estate, and I don't have the ability, the jurisdiction. Even if you say Joe defrauded mom, and that's why it's not, that's how he got the deed. He coerced her into it. Probate court's going to say, well, then you got to go to civil court. You'll have to go to superior court, convince that judge that there was fraud, once you've convinced that judge, then that judge will send them, the jurisdiction of the file back to me. But until then, I don't have the ability to say, yep, mom got defrauded. Okay, probate court can only take jurisdiction over the things that are still in your name. You have not set up a beneficiary for it. So what about personal property that we haven't talked about, like your gun collection or your coin collection or whatever? I tell people to do a bill of sale. A lot of folks, especially older folks, have put stuff on the back saying, I want the grandfather clock to go to Jane, and I want, that doesn't legally work. People do it, a lot of families honor it, that's great. But it's not the legal way to do it. So I tell people to do a bill of sale, just like you would if you sell a car. You can say, I give all of my stuff, all of my personal belongings to Angela, but I'm keeping the life use of it. Okay, so you give me all your stuff, but you're keeping the life use of it. That means if you die, I get all your stuff, but until then, I don't get anything. Okay. So I tell people to sign that to their kids. It's not a complicated thing. You don't need an attorney for it. You do have to remember to say, I'm keeping the life use of it. And then you got to tell your kids or loved ones where it is. Put it in your safe or with your deed or wherever you keep your important papers.
So, growing up, and as a young adult, again, just going back to, it was like, oh no, you don't want to trigger a probate. That would be terrible. What triggers probate?
Okay. The only thing that triggers probate is having items in your name after you die. So
Okay.
owning stuff when you die. So most of the documents we've talked about, what happens is upon your last breath, that property goes to whoever you named as beneficiary. Now, it's legally that's what happens. In reality, you're going to have to wait until death certificates are issued, so that they can prove you actually died. But the law is, hey, upon my last breath, that document that I signed saying you get this when I die controls, except in a will. So people will say, well, in the will it says I get this, but a will means you still own it. So if you own things when you die, it has to go through probate court. So what I try to tell people is the goal is to make it so you don't really own anything when you die. You keep the ownership interest while you're alive, but you've given the future interest of it to your loved ones.
That is a great sentence. So just say it one more time. So make sure, correct me if I'm wrong, that when you die, you don't own anything.
Right. You've given the future interest of all your stuff to someone else.
Okay.
And you need to do that in a document that's either a deed or a bill of sale or naming as a beneficiary. Now, another way to do it is to set up a trust. Most people that come to my office want a trust, and most of them I tell them they don't need one. Trusts are extremely expensive to set up. I would say I end up with lots and lots and lots of probate cases because somebody forgot to put something in trust. So after they set the trust up, they go and buy a car and forget to put it in the trust name, or they get a checking account and forget to put it in the trust name. And so that asset ends up coming through probate. And so a trust is a great thing if it's done right, but it's amazing how many aren't completed. In those cases, if you do set up a trust, what your will say is everything I own to my trust. And so your estate will be opened and everything will go to your trust, and so then the trust still takes it. But it's still it's a painful process for most folks, just because of the paperwork. There was something I was going to say about real estate and it just left me.
Well, while you're thinking,
Mhm.
yeah, Janice, please.
If you're doing the bill of sale kind of thing, do you just simply write that up on a paper? Does it need to be notarized or anything like that? And you just sign it and put it in with your um, final papers?
Technically, no, it doesn't need to be notarized. Some people get it notarized so that especially if you suspect somebody might fight about it, might be a good thing.
Okay.
But there's no, just like a bill of sale for the car, there's no requirement that it be notarized.
Uh-huh. And you had said that you could say something like, I give all of my personal belongings to so and so, and just like a generalization of
Yep.
and that will then release you from owning it at that point once you've passed.
Right. Don't forget to say that you're keeping a lifetime use of it.
Yes, and with lifetime use. Okay. So it's kind of an informal thing,
Mhm.
but binding.
Yes,
Okay. Thank you.
no problem.
And I'm going to ask one more question before we get lost. Excuse me. Is it acceptable and or legal to have both an advance directive, say you've done the Vermont one and you filed it, and 5 wishes? Is that okay that you have both?
It is. So the other documents I talk to people about are advance directives. And I tell everybody you don't need an attorney for an advance directive, and really shouldn't even, that shouldn't even be your first go-to. Your medical provider is a better person to chat with about your advance directive. But I always talk to people about it because they're captive in the office and I want them to have one. So an advance directive tells other people what to do with your body while you're alive. It also has a couple things about what your last wishes for your body is when you've passed. But the main reason to have one is what happens to your body while you're alive. An advance directive only takes effect if you cannot communicate. So even if you're incompetent but can communicate, technically you win. You get to make your decisions. Often medical staff won't ask you if you've been declared incompetent. So you want somebody that's going to go, hey, I know what they wanted. So very, very important to have an advance directive. That is much more important than anything else that an attorney can do for you. That document says what you want done regarding antibiotics, regarding intubation, tube feeding, CPR, different. Now, the 5 wishes part of it is much more specific, where the advance directive is sort of general. They're like, oh, I don't want nutrition, I do want nutrition. The 5 wishes part of it can be much more, more specific. And I tell people, you really should be specific with your loved ones. Whoever you're appointing, you're going to want to be specific with. And the reason you want to be is the big things I see up here, and obviously you can have anything, cancer and memory issues, either dementia or Alzheimer's or some other horrible brain illness. And if people haven't had this specific conversation with you, they often will do what they would do in your situation, not necessarily what you would do. Religious preferences come in here, and there's no right or wrong answers. Some people with cancer, for instance, say, I'm leaving this world with everything I came in with. And some people say, you know what, cut everything you can cut off me and keep me alive. And there's no right or wrong answer. It's a personal preference. But if nobody knows that preference, the default is going to be what they want to do, what they would do in your situation. Now, it gets even worse than that when you start dealing with very personal areas of your body. So most people are like, oh, you got to cut the end of my pinky off, no problem. But when you start taking out a breast lump or something in the reproductive organs, people get persnickety and they have very, very set ideas of what should happen there. And again, no right or wrong answer. The court, if there's nobody has done these and the person is incompetent and it comes in front of the court's response, unless it can be proven otherwise, is going to be keep them alive and comfortable. That might not be what you want. Depends. And that decision changes over time. So right now, while you're healthy and running around, well, you might want certain things that you might not want in 25 years. 25 years, you might say, you know what, I really don't want to do that. I'm good. So it's something you should review. You should review based on your health, your current situation, how your feelings have changed, that kind of thing. Cancer especially is such a dynamic issue as far as what kinds of treatment you can have. Usually when you get a cancer diagnosis, you get this whole range of we could do this, or we could do this, or we could do this, and these are the odds of, and they give you all these choices. And it's a terrible thing for a person to have to decide, but it's even more terrible for somebody to decide for you. So have that conversation. Now, I say that, but most kids don't want to have the conversation. They will change the subject. They don't want to talk to you about it because they're never, ever, ever going to be ready to lose you. Doesn't matter how old you are, how old you get, how sickly you are. They're not ready. They never will be ready. I had somebody in here a little while ago said their mom had been in a nursing home for a long, 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 long time. She was quite elderly by the time she passed, and they still didn't expect it. They just weren't ready. And I've just never seen anybody ready. So some people don't appoint a kid. That's the other thing with advanced directives. You really, really got to think about who to appoint. Sometimes a kid can't take it emotionally. They can't shut you off if that's what you want. They've done studies. Kids do two major things that are different than what parents would want. One of them is that they put the parent in a nursing home quicker than the parent maybe would have gone, usually because they're worried, don't want you to fall and be on the floor for 3 days. The other thing that they do is they keep you alive longer than you would have chosen to be kept alive. Again, not to be mean, just because they're not ready. I've seen situations where the person came into me personally and said, I don't want to go through this again. I've had cancer before. I'm not doing this again. I just want to be left alone. And the kid that they appointed put them through every hoop because they weren't ready. Go ahead.
Yes.
If you have both an advanced directive and the 5 wishes, does one take precedence, or are they both kind of legal? Can you have both simultaneously?
You can have both simultaneously. The 5 wishes is used more as a guide of what you would prefer to have done. The advanced directive is still going to leave the final decision in the agent's hands unless they're making a decision completely against what you've listed. So let's say you say, under no circumstances are you to cut anything from my body. I am leaving with everything I came with. And the agent says, nope, they gotta have their foot cut off to live. We're cutting the foot off. And it's been very clear in your 5 wishes, what your preferences in life are. Well, then somebody can bring it to court and say, you know what, this person isn't doing what they were supposed to do. So the 5 wishes, I would say, is more evidence. The advanced directive is a guide, but it does appoint somebody to make a decision for you if you can't. And unfortunately, you can't think of every potential situation you'll be in.
Well, and 5 wishes you do have to put in, identify agents, health agents. Yeah.
Right, but I think the advance directive would take precedence over it if you do both. So if you put
on
me
the
in,
identification of the agent.
yeah,
Okay.
so if you put me in as your advance directive agent and then you put Trish in as your 5 wishes, I'm gonna go out on a limb and say I think the advance directive wins. Now, if there's a big difference in timing, like if you do it at the same time, I'd say the advance directive wins. If you do one and then several years later do the other, the most recent one's gonna win.
Okay.
Unless somebody can show you weren't competent when you signed the most recent one.
Okay. Thank you.
Marco?
Yeah, hi. I think I'm the only one here that's not from Vermont. I'm from New York. So now, I've never heard of 5 wishes. Is that similar to like a MOLST form?
I
No,
don't know because I don't know what the
Mhm.
form you just referred to is,
no,
but
that is what what Margot is referring to is in Vermont is the Colst, or yeah, there, thank you, Beth. Margot, I'll send you the link to it and we can go through that. Yep.
Okay, and then also, I mean, I don't know if you know, but as far as the last time I checked, there was no enhanced life estate deed for your house in New York. And that's why any class I've ever gone to, they push the trusts.
yeah,
Um,
and
but,
that may be true in New York.
yeah, I don't know if that has changed. I have it in my notes to check that in case it's changed in New
And
York.
yeah, you'd have to check with a New York practitioner. I do know that most states don't offer that enhanced life estate deed option. Vermont
Right.
is still pretty good about that.
Yeah.
And
And
people have tried to change it because they want to be able to go after the house for Medicaid, and they've never gotten it through, our legislature to change it.
And I also found, because I had suggested it to my sister who lives in Tennessee, and theirs is slightly different
Okay,
on the what do you call it? The receivers, like in Vermont, they can't come after our house while we're here.
right,
In Tennessee, it was kind of open.
yeah.
That they could. So you have to really pay attention and look at that.
Well, see, in Vermont, they can go after it. It's just been
Right.
Medicaid's policy to never do that.
Right.
So they
Okay.
haven't done it. And that's been the policy for as long as I've been practicing. They
Well, and
assume your attention is to always go home.
right. And so I guess the maybe what like my understanding of the one in Vermont is like our kids can't say anything about like if we want to sell it, and it won't be here. They can't say anything about that. I think if I read it correctly, in Tennessee they can.
Okay.
So again, the point is to Margot, have those questions so that you can ask.
Right. And the other thing and I have kids come in all the time. Mom goes into a nursing home. She knows she's never coming home. And she's like, you know what? Let's just sell the house and I'll give you guys all money now. And they can't. They can't sell. If the house gets sold during the grantor's lifetime, it has to be used for their care.
Okay.
Has to be kept
Christine
until.
has, okay.
Yeah, thank you. Am not sure that I understand. I don't know what 5 wishes is, and how is that different from the advance directive?
So 5 wishes, it's on the Vermont Ethics Network. It's one of the Vermont Ethics Network forums, isn't it, Trish?
It is on there, yes. And I can send you the link to that
Is
as
it
well as
well, you mentioned the COLST, right?
Mhm.
right.
Right. Well, on my I have a DNR
Uh-huh.
/ COLST.
Uh-huh.
Is the DNR a 5 wishes?
No. Well, it has, again, as Angela was talking, that's more specific. I will send you that information so that you can look at it. I like the 5 wishes personally
I do too.
because it asks practical questions, whereas the advanced directive that's on the that Vermont has, I was like dizzy. I was like, what? Because it was, and or if, but it was the language for 5 wishes is very straightforward.
Well, I've done
But I
the
could,
advanced directive twice now, so, and I just
Okay.
redid it, so do I still need a 5 wishes?
you
Well,
don't need it, but I'll give it to you to look at. But go ahead, Angela.
no, that's what I was gonna, it's not necessary, but you might want it.
Okay,
Mhm.
I'll take a look at it. Thank you.
So
Welcome.
Colst, just to go back, a DNR Colst form, if you don't have one of those, sometimes people come to court and ask the court to issue one. And it's a very harsh thing for the court to do because the judge doesn't know this person. And people come and say, oh yeah, they wanted to be let go, or but they don't have any proof of that. So if you're able to do a COLST or a DNR form with your doctor, you should do one. And I'm not trying to tell you which way to choose. You can say, look, I want to be kept alive forever and ever and ever. And
Yeah,
and
yeah.
you can put that on the form.
Yeah.
So if that's the case, go for it.
Yeah.
There's no right or wrong answers on that one either. But definitely do your own, because
Oh, yeah.
otherwise strangers decide this stuff for you.
No, I've
Yeah.
got that. I've had that done for a few years now
Okay.
with
And
my
Beth-
doctor, the form with the doctor at the hospital.
Okay, brilliant.
Beth had a question,
Nadine
and then
Yeah.
Mrs. Richardson.
Go ahead.
Nadine,
and Beth.
can we go back to that enhanced trust again? I understand that this is my house. My kids aren't going to come in and tell me you're going to sell it. And, oh, I found somebody and it's for sale and we have a contract. I understand that. But what worries me a little bit is that if anything happened to them where they are sued, my house is at risk of being taken.
Right. So here's the thing. Normally I ask people, hey, does it look like your kids have this trouble or that trouble? But life happens, and even if they don't have those troubles when you first do the enhanced life estate deed, it can happen so that, okay, now son number 4 is getting divorced. Didn't expect that, but they're getting divorced. I tell people, come back in, let's take son number 4 off. We take him off the deed.
Okay.
And then once his divorce is final, we can put him back on. But for now, we take him off. So the most common reasons we end up taking kids off is divorce or bankruptcy.
Okay.
Now, technically, they don't own anything. So technically, divorce court and bankruptcy court should not go after those things. They don't own anything until you die.
Right.
But I find in divorce court, about half the time, the divorce judges don't know that. And bankruptcy court doesn't care. They go after it anyway.
Yeah.
Okay.
So you do have some wiggle room.
Yes.
Good.
Because you can take the kids off it as many times or as often as you want.
Wonderful.
I had one lady come in and take lots of kids off and then put them back on and take them off. And she
Okay.
was sane. They were just making her mad. So
Well, I don't think I'll go that far, but
okay.
thank you for
And
that.
Beth, you had a question.
Oh, no, I was just going to say that the 5 wishes to me is just more about your personal wishes. Like, it's the other one, the advanced directive is very clinical. The 5 wishes kind of brings it down to a very personal level. So I love having both of them.
Yes. The other thing is, if you go onto the online to get your advanced directive, there's 2. One's the long form and one's the short form. Don't get frightened by the long form. The long form is usually for folks who either have had or may need in the future electric shock treatment. So most people do the short form. But if you are somebody who's a likely candidate for electric shock treatment, you may want to look at the long form. But that form's like, when I say long, it's like 27 or 30 pages.
Yeah. Mary and then Janice. Mary, unmute.
No, okay.
There
Okay,
you go.
you, okay. I was wondering, what advice would you give to people who are looking for a lawyer, who are elderly and they need a lawyer? Maybe they're looking for this enhanced real estate. How do you tell that before you make a decision who you're going to go see? Is there a little subparagraph under their name or
No. So
no?
you have to ask them if they'll do an enhanced life estate deed. I've
Yeah.
actually had people come in, be furious that their friend attorney who set up their trust hadn't done that.
Mhm.
I told them, well, go back to your friend attorney. Hey, it's going to be cheaper. And they did. And the attorney said, I don't believe in them because I don't think you should get out of paying for your nursing home care.
Mm.
And so you really just have to ask them, do you prepare enhanced life estate deeds?
Yeah.
And if they say no, then they probably have a moral problem with it.
Mhm.
Interesting.
And the other thing you might want to ask is how much they charge for them. And there's a vast difference between what attorneys charge for these things. Some attorneys don't charge anything extra than a quitclaim deed. And some attorneys charge, I've seen one bill for $7,000 for an enhanced life estate deed. Yeah, that's a lot of money. I charge about $100 more than my warranty deeds for mine, because I end up talking to them a lot more than I would talk to you about a regular deed.
Mhm.
And I also kind of build in that the kids are going to call me. And so the kids call and ask questions, and that's fine. But some folks, there's an attorney in the area that charges $2,500 to do an enhanced life estate deed. There's other attorneys that charge $750. So you really want to ask them, because
Yeah.
that one really varies. Most attorneys' fees don't vary that much, but for that one, that one's all over the board.
Mm. Thank
Wow,
you.
that was a good question, Mary. Dennis?
Just have a quick question. Back to the 5 wishes again. I have one in hand, and at the end of it, where it says signing my 5 wishes, the last sentence says, I also revoke any healthcare advance directives I have made before.
Wow.
So that's why I was wondering
Mhm.
if you could have both, and if one. So I wasn't sure what that sentence meant exactly.
Well, I'm glad you pointed it out. It sounds like, unless you cross that sentence off, that it revokes your power of attorney, your advance directive.
Oh, so can you just cross it off?
Mhm.
Okay, good to
Thank
know.
you.
Thank you.
Good catch, Janice.
Yes, very
Mhm.
nice.
Okay,
Well,
thank you.
I want to respect, we could go on, I'm sure, all night. I want to respect Angela's time. So one more last call for a question, and then I want to just do appreciation.
Just one quick question.
Mhm.
You spoke about the transfer tax,
Mhm.
and so would that be applicable to a sister or say an ex-spouse?
Yes.
Mhm.
So unless the ex-spouse is tricky, if you have a divorce decree that says you're supposed to give property to them, there's no transfer tax. But without the divorce decree that says, hey, you're supposed to give, 290 Water Street to them, then they have to pay a tax on it.
Mhm.
The sister, yes, there's no exemption for siblings.
Oh,
And it's really harsh, especially for folks who don't have kids. A lot of times they give to their siblings or their nieces and nephews, and it creates a hardship because they end up having to pay a transfer tax.
and is it usually a lot of money, Angela?
Well, because it's not going to be their primary residence, yeah, it can be. I mean, I think the minimum is 1.25%. And when you're talking about a $200,000 property, what's that, $2,500? Something like that?
Can't add that quick. I mean,
Yeah, it's quite a bit of money.
Mhm.
And the worst part about it is they shouldn't have to give it because you can revoke it, so they could pay a transfer tax and it get revoked.
Mm.
What I've been doing, and I haven't been nailed on it yet, so what I've been doing is taking the life estate tables and applying it so that it lowers the transfer tax. But it might lower it, 50%. It depends. It takes your age and then it figures out what percentage you can charge. So I have been applying the life estate tables to the transfer tax.
Great idea. Thank you.
You're welcome. Margot, did you have a question?
Mwah. I can't thank you enough.
Oh, no problem.
That's excellent.
It was
No problem.
really
Fantastic.
helpful. And other folks, including you all, will have, the link so you can go back and say, what did she say? Let me listen to that again. And you know that I'm passionate about proactive planning for end-of-life care. This is under that rubric. So, be kind to yourself, and that in turn, you're kind to your beloveds, so they aren't going, what?
One
Yep,
last
Beth,
one.
one more time. Yep.
So I have an attorney that is retiring. Are you taking new clients for things like just the enhanced estate or okay,
Yeah,
thank
we
you.
do. And I didn't give you my contact info, but the phone number is 755-6343. And the email address looks weird. It was supposed to say Ange Ross Law at Outlook. It looks like Ann Gross Law at Outlook. And so people say, is Ann there? But it's supposed to, so it's ANGROSSLAW at outlook.com.
Thanks.
So,
And I can do a follow-up with you. Go ahead.
yeah, and I can't help people get through probate court anymore. I can help them, even if it's in a different county, I can't. But it can help them avoid probate. So I can still do those kind of deeds and stuff like that.
Perfect.
Well, thank you so much.
Yeah.
This is
No
wonderful.
problem.
Thank
Call
you.
Yeah.
or
Thanks
email
for
me if you have
arranging it,
questions.
Trish.
Yeah,
And
thanks.
you're welcome. And I'll share Angela's contact information. So if you have a follow-up question, like remind me what you said. Okay.
Great.
Thank you.
Thank you.
Take
Bye,
care.
everybody.
Take care.
Everybody.
Bye-bye.
Stay well.
Yes.
You too. And warm.
Yeah.
Bye.